So dear students, I welcome you once again to this class on business law. In this video, we will be looking into what is called consideration, which we deal with in the Indian Contract Act 1872. So we know that for a contract to be formed, there are four steps, and the initial step is creation of a proposal or an offer. So when an offer combines with acceptance of the offer, it becomes a promise. And when a promise combines with consideration, it becomes an agreement. So let's see what an offer is once again. The definition of offer according to section 2 subsection A of the Indian Contract Act 1872 is when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of the other person to such act or abstinence is said to make a proposal. So here, when one person signifies his willingness to another to do something or to abstain from doing something, so that is called a proposal. So when proposal combines with acceptance, it becomes a promise. So here we see, according to section 2 subsection B of the Indian Contract Act 1872, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So a proposal, when accepted, becomes a promise. So now we will see what is called consideration. So we know that when a promise combines with consideration, it becomes an agreement. So we need to understand the definition of consideration here. So according to section 2 subsection D of the Indian Contract Act 1872, when at the desire of the promiser, so we need to understand this, so not at the desire of the promisee but at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing. So here it is differentiated into three scenarios or tenses here. So past tense, present tense, and future tense. So has done something or abstained from doing something, or else does something or abstains from doing something, present tense, or promises to do or abstain from doing something, future tense. So such act or abstinence or a promise to do is called the consideration for the promise, right? So for example, we can say money. We can take money as a consideration. We can take land, a deed of land as a consideration, or title of the goods or title of the land as consideration. So again, when this consideration combines with promise, according to section 2 subsection E of the Indian Contract Act 1872, every promise and every set of promises forming consideration for each other is an agreement. So consideration is actually the legal evidence of the intention of the parties to create a legal relationship. So whenever a legal relationship is created between the promiser and the promisee, there should always be a consideration. So when we see the second point, when a party promises to do something, he must get something in return. A promise thus given for value is enforceable by law, right? Only a promise with consideration will be enforceable by law. And when you see the third point, if there is no consideration in the agreement, if there is no consideration with the promise, that would be called a gratuity, which is given something which is given for free. Okay. And so as we discussed, again, an agreement without consideration is actually void, which means it cannot be enforceable by law. So each and every promise which when it combines with consideration, it becomes an agreement, and only then it can be enforceable by law. Okay. So consideration is a price or a return for a promise. So when we look into the example here, again, we can take the same example as we have discussed before. So X agrees to sell a house to Y for rupees 50 lakhs. So X has agreed to sell a house to Y. For this, amount, rupees 50 lakhs. For excess promise, the consideration would be rupees 50 lakhs. And for wise promise, the consideration would be the house here. Okay. So next we will see the types of consideration. So there are the three types of consideration here. Executory or future consideration, executed or present consideration, and finally you have past consideration. So when we look into the first future consideration, uh, so here uh, a promise has been given to be performed in the future, and the payment is being made now. Okay, so for example, when we say Babu receives a payment and then he promises to deliver goods in a future date. So he receives the payment today and he promises to someone to deliver goods for that person in a future date, okay, to do something in the future. So that is called future consideration. So what is present consideration? So present consideration means that consideration takes place simultaneously with the promise. So example, Raju purchases a shirt from a retail store and pays the price immediately. So he checks for a shirt in the retail store, and he buys that shirt, and he pays for the shirt right away. So that is called present consideration. And what is called past consideration? So past consideration means consideration has been done before the date of promise. So before the promise has been done, consideration has already been completed. Right here, if you see this example, Shalu does some work for Balu during January 2020 and expects nothing in return. Okay, expects no payment here. Okay, Shalu does a work for Balu during January 2020 and he does not expect anything in return. But during December 2020, now after 12 months, Balu promises to pay Shalu some money uh, in return to the work that he has done in January 2020. Okay, so here one consideration has been completed in January and the promise has been made during December 2020. So here this is called a past consideration. So these are three kinds of consideration here. So next we will see the essential elements of a valid consideration. So what are the elements that are required in a valid consideration? So first is consideration must move at the desire of the promiser. So as we discussed in the previous slide, so consideration must always move from the at the desire of the promiser, only at the no condition of the promiser, not at the condition or the desire of the promisee. Okay, so if a promisee demands anything in return, that would be called a counter offer. So here consideration must always move of the desire of the promiser only. Consideration must be real and not unreal or fake. Okay, it should be worldly. Okay, so it should be maybe material things like money or house or land, etc. Okay, it should be a real substance. uh, Third one is consideration must be lawful. Okay, it should not be unlawful. For example, when we take an example of someone selling liquor in, for example, Tamil Nadu, wherein liquor is banned for selling by private people, but only the government agency can sell, right? So liquor is banned in Tamil Nadu. So consideration here is unlawful when you take this example. So, for example, if you take uh, Mexico, there drugs, illegal drugs. If you take marijuana, it is lawful there. Okay, selling of marijuana is lawful there. So there, the consideration when we talk about selling of marijuana is, it is obviously lawful. But in India, when we take certain things, certain products, it comes to as unlawful when we enforce it by law. So every time a consideration has been promised, it should be lawful. Next one, consideration may be an act to do something or abstinence or a return promise. So to do something or not to do something or promise to do something. Okay, three things here. To do something or not to do something or to promise to do something. So consideration may be all the three. Next one is consideration may be of the past, or just we what we looked into in the last slide. It can be a past consideration, it may be a present consideration, and it also might be a future consideration. And the sixth point, consideration need not be adequate. So consideration according to law is not adequate. We cannot give a proper value for consideration. It is only based on the two people, the two parties to the contract, who are the promiser and the promisee. Only based on their demands and their the demand of the promiser, or desire of the promiser, or condition of the promiser, the amount of consideration varies. Okay, so consideration need not be adequate, or need not have an adequate quantity. Seventh point is consideration must not be illegal, as we discussed before, immoral, or opposed to public policy. So against public policies, it should not be against public policies, or immoral nature, or illegal. Finally, consideration may move from the promisee. Okay, so consideration must move at the desire of the promiser, which we saw in the first point. Consideration may move or be transferred from the promisee to the promiser. So these are the 8 essential elements of a valid consideration. So finally, we look into what is privity of contract when we talk about consideration here. So privity of contract is the relationship subsisting between both the parties, who are the promiser and the promisee, who have entered into contractual obligations with each other. So that is a relationship. So privity of contract is a relationship between the two parties. So there is a general rule that when two parties come into a contract with each other, only the parties to the contract may sue or be sued. Okay, maybe if promiser and promisee get into a contract with each other, if promiser or the promisee does not comply with the obligations, or complete or perform the obligations of the contract, a promiser may sue the promisee, or the promisee may sue the promiser. But a third party cannot sue the promiser or the promisee in this case. Okay, only there is a chance in which a promiser can sue the promisee, or the promisee can sue the promiser, but any other third party may not be able to sue both these parties to the contract. For example, a contract between Sam and Govind cannot be enforced by Aravind. So that is called privity of contract. So that's all for today, students. So thank you so much for listening. Thank you.